Test, 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 test. Okay, sweet. And then you can go ahead and test the microphone and the speaker.
Morning, ladies and gentlemen. Our first case for argument this morning is Coyle Nissan against Nissan North America. Mr. Flowers.
Good morning, Your Honors. May it please the Court, my name is Paul Flowers. I represent the plaintiff appellant, Coyle Nissan, LLC. I'm joined by my co-counsel, Ronald Smith. We are here on a dispute between an automobile dealer in Clarksville, Indiana, and the Nissan car manufacturer. I'll probably refer to Nissan, the defendant appellee, as NNA at times throughout this.
I think you would do a lot better by using real words rather than made-up initialisms.
I will do my best, Your Honor. This all started in 2012 when my client, Coyle Nissan, purchased a Nissan dealership in Clarksville, Indiana. My client, Coyle, had been involved for 3 generations in the Chevrolet dealership business, which had been very successful, and they were moving on to Nissan. What happened over the next several years was a course of events where the parties were required to pick a location, and there's no dispute that the intention was that my client would construct a state-of-the-art standalone Nissan car dealership competing with the nearby Toyota and Honda dealerships. Never any dispute about that, but the question was the location.
But can I interrupt? We have I think we're well versed on those facts. One of my burning questions for you is, we see that Nissan North America extended the deadlines routinely,
Right.
and then ultimately approved the Broadway site. And what is not clear to me from the record is why, after all these extensions, and then you've got new deadlines, Coyle does, for April 15th, 2017, October 1, 2017, complete construction 18 months was the final set of extensions at issue here. Why Coyle file suit instead?
Well, 5 years had gone by in which Coyle had made a tremendous investment of both time and effort into locating a suitable location, and it was just not economically feasible by that point in time for them to proceed with this planned state-of-the-art facility.
So Coyle got that last extension, but at that point had no plans to then continue on with the idea of building a facility
the plans
on the Broadway site that has now been approved.
Right. The plans always were to proceed there. Now, remember, this was the Broadway site that was rejected in 2012.
I know, but now it's approved.
Right, approved 5 years later, at a point in time when they had lost out on incentives. They had not been making the money they thought they were going to make. They had invested quite a bit in not only locating this property, but also in purchasing an option that then expired. It just was economically so far late in the game that it didn't make sense for them to proceed. They couldn't proceed. And then once you file the litigation, everything stops. I mean, it doesn't make any sense to proceed with that kind of investment until the court rules and determines the rights and the parties' rights and obligations between each other. That's really how it all evolved. And it was the constant delay, the constant changes, the shifting goalposts throughout that 5-year period that really put Coyle in a very financially precarious position. Had this been approved at the beginning, I mean, had they not waited 5 years to approve the Broadway site, then absolutely, that would be there right now. State-of-the-art facility competing along with the nearby dealers, there'd be no question about that. But that goes into the whole question of good faith and how Nissan, the manufacturer, was responding to all this, which is a 4th count of our complaint.
So, Mr. Flowers, what is your best evidence that Nissan did not act in good faith?
Well, I think what jumps out to me, the best evidence, is the fact that they had this 2010 report, this economic study, that they don't disclose. And
but does the contract obligate them to disclose that to Coyle?
No, which is what they say. They say, we didn't have to. But that's the whole issue of good faith. And that's where the district court goes astray here.
But isn't good faith, however, it's moored at least to the terms of the contract, right? So when the contract gives a party discretion, that's kind of when good faith kicks in. But the good faith obligation doesn't by itself create any independent obligation separate from what the contract provides.
No, I completely agree. What we've got here is a situation with complete control through this agreement. The discretion on Nissan getting to pick the location, that's not there. I mean, they get to approve it, but it's subject to terms and conditions and so forth. Even they say it's not unfettered discretion because they're trying to get out of that bad faith angle. But what the trial court missed here was that the concept of good faith, as well as these dealer protection laws that we're citing, go beyond just simple principles of contract. I mean, we've already had a cause of action for breach of contract.
Actually, what Judge Lee just said, and what you agreed with, is that this duty is a duty to keep the contract in good faith. And you've agreed that Nissan kept its contract. And in fact, more importantly, that's what the jury found. This case was tried. The jury found that Coyle breached its contractual duties and Nissan did not. I don't understand what could be left in this case, given the jury's verdict.
Well, let me back up there. The jury trial was limited to the Second Amendment. All the jury found was that Coyle had not complied with the Second Amendment, Nissan had. The Second Amendment just dealt with the belated approval of the Broadway site in 2017.
I think you might want to expand on that. When you say Second Amendment in a federal court, people think about guns.
Right.
The Second Amendment to some particular document.
Mm-hmm. Yeah, it should be more clear. The Second Amendment to the Dealer Services Act, which was adopted once Nissan finally approved the Broadway site in 2017. That jury trial was limited to that. And there's a whole lot more to this contract than just the Second Amendment to the agreement, not the Second Amendment to the Constitution.
Nor the Second Amendment to some statute.
Correct. So that jury trial is just limited to that. We still maintain that Nissan breached the agreement because they didn't approve a site that was approvable. And just going back to your question, Judge Lee, about the best evidence, I mean, what jumped out to me was we had this 2010 study, or Nissan had the 2010 study, saying you should build on the west side of I-65. That's the preferred area. That is right where the Broadway site is, and a couple of other sites that were proposed. And you're right, the agreement didn't require Nissan to disclose that. But the concept of good faith, and this is going back to what you were asking Judge Easterbrook, in California is just that you cannot defeat the other party's right to the benefit of the bargain.
I thought, though, that Nissan noted like the other issues with the Broadway site, which was the lack of visibility and kind of the fact that it was behind kind of the main thoroughfare.
Tucked away.
Right, exactly. And that seems like things that Nissan, within its discretion, when it looks at, I mean, the contract allows Nissan to look at kind of the marketability and like commercial viability of the place. Mm-hmm. Those factors seem to fall within that category.
First of all, those are matters of pure subjective belief. I mean, purely subjective. We don't like the accessibility. Now, it's weird because this is going to be built on Broadway Avenue, Clarksville. Broadway Avenue, right there. But they say it's not accessible. This is not a dead-end road. This is not something that just goes nowhere. This is Broadway Avenue. It is close to I-65. You can see the frontage going all the way up and down I-65. It's accessible. It's visible. It's just as visible as the Honda and Toyota dealers there once the signs are up and so forth. So that's something where a jury could say, no, that's nonsense. We're looking at photos of this, and it's just as visible, it's just as accessible as the other dealerships in that area, if not more so. So the judge took that away by first granting judgment on the pleadings on the claim for fiduciary duty, and then later summary judgment on the remaining claims. The jury never got to question whether Nissan's assessment was accurate. And as far as discretion, I mean, they're trying to play both sides of the fence. I mean, they're saying we had the discretion to pick. We could reject this if we wanted to. But then when you get to the fiduciary duty claim in good faith, they back off. And they say, well, it's not unfettered, and they're right. I mean,
you raise a good point about the fiduciary duty claim. If we could focus on that for a second. It seems to me that at least current Indiana law seems to indicate that where there's a contract between two sophisticated commercial parties, and I think Coyle would count as a sophisticated commercial party.
Thank you.
That there's no place for, a fiduciary duty. That one party doesn't owe a fiduciary duty than the other outside, because you have the contract that dictates those obligations.
Right, and that language about the sophisticated parties at arm's length comes from that Ray Skillman Oldsmobile case they're citing. And in that case, that contract disclaimed a fiduciary relationship, said there is no fiduciary relationship. That's not in here. That's not in here. And it starts off with the introduction. I'm going to insert the parties' names. Coyle has entered into this agreement in reliance upon NNA's integrity and expressed intention to deal fairly with Coyle and the consuming public.
But doesn't that that obligation kind of went both ways, right? Isn't there a similar provision that Nissan also entered in the contract, assuming that Coyle would, act in good faith?
Oh, I wouldn't disagree. Right, of course, Coyle's got to act in good faith as well. It's a two-way street.
I guess my question is, typically when two parties have a contractual relationship, we are loath to find some sort of fiduciary duty from one party to the other because that would basically, void or vitiate kind of what the contract was for. Mm-hmm. And so what factors here do you think give rise to a fiduciary duty between Nissan and Coyle?
Well, it's like the Aston Martin case. It's the control and the confidentiality. I mean, this agreement gives Nissan almost complete control. There's no autonomy. They have control over the facility, including the ceiling tiles that are allowed to be used. They have control over the sales. We don't get to pick the cars we want to sell.
Isn't that the case, though, for any franchise or franchisee agreement?
It doesn't appear so, because there's some cases that say, like, oh, there's autonomy here. And they don't explain it, so who knows?
Well, this leads me into a question I have about there's this part of the reply brief where you say you weren't allowed to develop evidence in support or engage in discovery and offer evidence on this fiduciary duty claim that you're discussing with Judge Lee. What helpful evidence do you think you would have dug up on this?
Well, we've decided to just take the position that the evidentiary record was sufficient to justify a denial of summary judgment upon that. No, actually, breach of fiduciary duty was denied on the pleading, so we don't need evidence. But it's just the control. It is so thorough and complete in this agreement. Really, Nissan had no ability to do anything without Nissan manufacturers' approval. And that's okay, because you're assuming that there's this duty of good faith and that there's these fiduciary responsibilities here, and that's okay. We can live with that. But when the judge just says, they comply with the contract, your claims are dismissed, that's not the law. These dealer protection laws are here for a reason. So I'd like to save my remaining time for rebuttal. Thank you.
Mm-hmm. Certainly, Mr. Flowers. Mr. Wells.
Good morning. Good morning, Your Honor. Stephen Wells for Nissan North America. I'd like to focus my remarks this morning, with the court's indulgence, for a few minutes on the breach of fiduciary duty claim, and then spend some more time on the breach of duty of fair, I'll call it the bad faith claim. With respect to the fiduciary duty claim, the allegations in the complaint are about as bare bones on this as possible. They don't meet the standard of Iqbal. They don't meet the standard of Kapoor and the other Indiana cases, which say that one has to, that in accordance with the overwhelming authority in other jurisdictions, that a franchise agreement does not give rise to a fiduciary relationship, and that an arm's length contract does not give rise to a fiduciary relationship. And therefore, you must plead something different. You must plead exceptional or special circumstances where there is an unusual aspect of trust and reliance and confidence. None of that is in the complaint. In the Kapoor case, that's from the Indiana Court of Appeals, it talks specifically about an analogy here is to a trusted financial advisor. There's nothing in the contract in this case that would suggest that that Nissan was in the place of a trusted financial advisor. There were mutual obligations. There were mutual duties. Mr. Flowers says that Nissan had complete control. That's completely wrong. If you look at the marketing and advertising parts of this contract, they say specifically it is the duty of the dealer to engage in the marketing, to develop its marketing plans. As just one indication. The contract itself makes clear that this is a personal services agreement and relying on the dealer for the specialized knowledge and expertise of the dealer. So this is a contract with great mutuality. It's not a contract of adhesion. It was a contract between two arm's length and seasoned commercial entities. I would also point out that there just aren't any allegations of special trust or confidence. And in fact, the only time in the complaint where it says anything about the expectation of a confidential relationship, there's no mention, first off, there is no mention of confidential data or confidential information. The confidence that they allege in the complaint is that Nissan will do its duty in good faith. And that, of course, applies to every contract between two commercial entities. So there are no exceptional circumstances here. There's no
Mr.
indication
Wells,
in the complaint.
if I could stop
Yes.
you for a moment. What do you make of Mr. Flowers' concern that Nissan had this 2010 study and just simply didn't give it to, never really came up in its discussions with Coyle with regard to the Broadway site?
Your Honor, I think I'll just point out that I don't believe that allegation was made in the complaint with regard to the fiduciary duty claim. But it is made and expanded really for the very first time on the appellate brief with respect to the bad faith claim. So let me address it in that context, Your Honor. As Your Honor pointed out, there is no duty of Nissan to provide the 2010 market study. Second, there is no allegation in the complaint about why that fact is material. In other words, if you look at the complaint, the entire theory of the complaint is that Nissan took too long to approve the Broadway site. I ask rhetorically, what does what would the 2010 market study have provided, and how would that have changed the outcome here? No explanation is given.
Let me interrupt you there, Mr. Wells, because with this claim, we're under California law. Is that right?
Yes, that's right.
Yes, okay. So under California law, it doesn't require breach of a contract, or that some aspect of a contract not be adhered to find a breach of the implied faith of implied contract of good faith and fair dealing. In other words, just because something's not required by the contract doesn't mean that couldn't evidence bad faith, whatever the other party did. So given that, why isn't the 2010 study and Nissan being a little bit coy about that, and then also the changing preferences. One day they want east of I-65, the next day they want west, east, west. Sometimes they're not informing Coyle. Why couldn't a reasonable jury take those two facts and say there's some evidence here that Nissan was trying to frustrate Coyle's ability to perform this contract? Because that's all a jury would need to conclude.
Well, I'll try to address both of those questions, Your Honor. Number one, with respect to the market study, California law also says that the duty of good faith and fair dealing does not create a duty that's not found in the contract. So it doesn't impose additional duties. That's number one. Number two is I come back to
well, they're not saying that you were supposed to do it, but they're saying that may be evidence a jury could take into account of bad faith, the fact that you didn't do it.
Well, but what they're saying is that would only apply if we had some duty to do it, I think, Your Honor. I mean, I think that's the short answer to that. But there are many more reasons why that market study argument just doesn't fly, and I'd like to go through those, if I may, for a moment. Number one, that was a 2010 market study. It was out of date by the time and it had to do with another dealer, Bales, who was in a different location. So there was not only no obligation, but it was out of date, and there was a different, it was dealing with a different dealer in a different location. And Your Honor, number two is, this is an argument that was never fleshed out before the district court. Is there a mention of it? Yes, in one bullet point. The entire breach of contract, breach of good faith and fair dealing argument in the trial court, Your Honor, is limited to 2 paragraphs and less than a page. The very first time this argument was fleshed out was in the appellate briefs and of the appellant. And now this argument constitutes 16 pages of appellate briefing, where it started out as 2 paragraphs, essentially. So it was waived, Your Honor. This argument is forfeit. We all know the court's views about cursory references. This could not be more cursory. So that's an additional reason, Your Honor. This argument was forfeit and was waived. But let me come back to the issue of materiality. There is no argument from the other side about how anything would have changed if they had gotten the 2010 market study. They make a big deal about this preferred area. And Your Honor, this kind of bleeds into your second question. They give no indication of why Nissan's preferred area has any importance to them. In other words, what's at issue here is whether or not there were facilities and a location available in this entire geographic area that they were responsible for.
Isn't that somewhat of a specious argument that they need to establish why Nissan's preferred location is important to them, when their whole obligation under the contract is to come up with a site that Nissan will approve, and when half or more than half of the approvals amounted to Nissan saying it's not in our preferred area?
Nissan never turned an issue, never, Your Honor, in all the allegations and evidence before the court, never turned down a proposed site simply because it wasn't in a preferred area. That's undisputed. And in fact, Your Honor, Nissan approved a site proposed by Coyle that was in an unpreferred area because it was the only thing that was available. The grounds for Nissan's turndowns had to do with visibility, accessibility, and in one case, Your Honor, the fact that it was in an undeveloped area next to a pornographic store. Those were the reasons why Nissan gave. Those were all, there's no evidence that any of those were wrong. There's no evidence that any of those were in bad faith or intended to harm the dealer. So, Your Honor, I take exception to the notion that this is a specious argument. What's specious is the notion that that somehow they don't have to show materiality for any of the minor grievances that they're raising now for the first time on appeal. And that's what this amounts to, Your Honor. The fact that they disagree with the fact that Nissan didn't show them, at least initially, the 2010 market report, doesn't really, it's a grievance. It doesn't rise to the level of materiality because they haven't shown how that's important in any way.
But Mr. Wells,
and that's their duty, Your Honor. That's their duty.
Mr. Wells, you can see how Coyle, the Coyle parties might be a bit frustrated here, right? Because take that site next to the adult entertainment store. My understanding is at some point they had actually an option to purchase that site. They go to Nissan. Nissan says, no, we can't. We're not going to let that happen. We don't think it's appropriate because of the reasons that you cited. And then, but later on, Nissan comes back and says, you know what, that site would actually work. And by that time, Coyle's option, had basically expired. And so one could see how Coyle might be frustrated in this process because, as we noted, Nissan does seem to go back and forth a bit on its preferred options, as time goes on.
Judge, I don't think there's anything in the record that suggested that what they called the Jeff Town site next to the adult bookstore was later deemed to be okay. And what the record evidence shows, Your Honor, is that Nissan told Coyle, even before it entered into the contract, that was an unacceptable site. And that's admitted by Michael Coyle in his deposition, and we've cited that. So, Your Honor, they could not have had a reasonable expectation as to that what they're calling the Jefftown site. And Your Honor, I would say that the only site that there's evidence that Nissan went back and forth on to some extent is that Broadway site. And that has been fully explained. That was I'll call it a C minus, a D site. It was behind their existing dealership. It was not reasonably equivalent to the Toyota and Honda facilities down the road, which had perfect access, or frankly, even Coyle's dealership. So of course Nissan didn't, and again, Coyle was told before the contract was even entered into that one was unacceptable.
Mr.
But at
Wilson,
some point,
could I ask
Sorry.
you a bit about the declaratory judgment that the court entered?
yes, Ron.
And I know there's a dispute about that between the parties. So the judgment that was entered states that the jury rendered its verdict on claim 1, breach of contract, in favor of counterclaimant Nissan North America and against counterclaimant Coyle Nissan. However, the jury determined that Nissan North America was not harmed by Coyle's breach of contract. So my understanding is that under California law, one of the elements of proving a breach of contract is damages, right? And the jury, in its special verdict form, found that Nissan did not suffer any damages. So is it correct as a matter of law to say that the jury entered a verdict in favor of Nissan on that claim?
Yes, it is, Your Honor, because, and maybe I could just explain a little bit about what happened here in the short time I have left. So as we approach trial in this case, Nissan, this is all on the record, Nissan had a breach of contract claim and a counterclaim and a declaratory judgment claim. The breach of contract claim had attached to it a request for specific performance because, and specific performance we alleged was appropriate because damages were difficult to prove in a situation like this. As we got closer to trial, Your Honor, Nissan concluded that that specific performance was unworkable here. And you can see, Your Honor, in the transcript right before the case started, Nissan withdrew the request for specific performance. And so we were left with a breach of contract claim with no remedy, essentially, and the declaratory judgment. And what was important to Nissan, as we explained to the court, was the declaratory judgment claim, because that's important. That can be important for future administrative proceedings and the relationships between the party. Coyle argued simply that it was duplicative.
In the district court, did anybody ask for nominal damages?
No, Your Honor, not on that.
And
not
I haven't
on that
seen
claim.
any reference to it in the appellate briefs. Okay.
That's right, Your Honor. No, there wasn't. And so what was important to us was the declaratory judgment, and that does not require damages. And with that, I'll conclude my remarks. Thank you.
Mm-hmm. Thank you, Mr. Wells. Anything further, Mr. Flowers?
Yes, Your Honor, briefly. I do need to address this waiver argument on the 210 market study that had indicated that the west side of I-65 was the place to be, and the idea of this just surfaced on appeal, and that's not true. We know that because in the district court summary judgment ruling on page 2, she discusses the 2010 study in detail. Then she goes on page 3. However, Compton, that's Nissan's representative.
You would do better facing the court rather than trying to have us read papers 10 feet away.
Just trying to show I'm not making this up.
Just face us and talk to us.
Compton failed to inform.
Face us.
To paraphrase what the judge says on page 3 of the summary judgment order, Compton failed to disclose that they had that study indicating that the west side of the place was the place to be, the preferred area, while they were rejecting not just one, not just the Broadway site, but several sites on the west side without explanation and on grounds that really had no support at all in that study. That's the bad faith. That's the breach of fiduciary duty. Yeah, they didn't have to disclose it, but they were playing games. And the game turned into, guess where we want you to be now? East side, west side, up here, down there. Accessibility, non-accessibility. A jury could find that that's all bad faith, that they were denying Coyle the benefit of their bargain, the benefit of the contract, And so the dismissal of that claim just was not justified. And as far as the control, I mean, the exhibits to the complaint are part of the complaint. They are in there. And the attachments are extensive. Now, this is not a threadbare complaint. This is 137 paragraphs, 10 of which are devoted exclusively to fiduciary duty. And that includes the contracts. And the control they've got here is extreme. Advertising, yeah, we get to pick the advertising that they approve. Marketing, yeah, we get to do the marketing that they approve. Everything is subject to their approval, which they can withhold or not, with the exception of the location, which is debatable. Facility, yeah, they got to say a lot about how the facility was constructed. They did not necessarily get to say where it would be, and they certainly couldn't do that in bad faith. Just to get to the declaratory judgment, I know I didn't get to it, but it is important. And yes, you don't have to show harm for declaratory judgment
Thank you, Mr.
necessarily,
Flowers.
but you have to have an actual controversy. Thank you, Your Honors.
The case is taken under advisement. Our next case is in the matter of International Supply Company. Mr. Dabney.
May it please the court. Section 3 of the Uniform Fraudulent Transfer Act provides that a debtor is insolvent if the sum of the debtor's debts is greater than all of the debtor's assets at a fair valuation. This appears to be the first case in which a debtor has been deemed insolvent under the UFTA based on proof that admittedly does not satisfy.
Insolvent under the what?
I'm sorry?
Insolvent under what?
Insolvent under the UFTA, Uniform Fraudulent
Could you
Transfer
use
Act.
real words, please?
Yes.
You heard me ask the same thing in the first case.
My apologies,
We
Your
are
Honor.
generalists. Funny initialisms used only in a small specialty are wasted in a court of appeals.
I'm referring to 740 ILCS 160/3A, the definition of insolvent. This court has held again and again and again that insolvent prescribes assets being less than the sum of all of the debtor's debts. In this case, the bankruptcy court's findings were that at year-end 2012, at year-end 2013, a period spanning the payments at issue in this case, this debtor had assets whose fair valuation was comfortably high.
You're now pursuing the argument that's in your brief that only the balance sheet determines whether an entity is insolvent. How did you make this argument in the bankruptcy court?
The argument was made in the bankruptcy court through expert testimony, which...
No, you make arguments in the bankruptcy court by filing legal documents,
Yes.
not by expert testimony. You're well aware that your adversary has said that the argument you're now making was either forfeited or waived in the bankruptcy court. Your reply brief says it was not, but doesn't tell us how and where it was raised in the bankruptcy court. That's what I'm asking you to focus on now.
Okay. The SEFCU joined issue on whether or not the debtor was insolvent. It was the trustee's burden to prove if it was going to proceed on the theory that the debtor was insolvent, not that the debtor had unreasonably small capital, not that the debtor would lack sufficient property to pay its debts. It was the trustee's burden to prove.
I wish you would deal with my question.
And so the way we presented evidence through an expert.
You have to make a legal argument. You file a piece of paper saying the only thing that matters is the balance sheet. Where did you say that? Your adversary says you contended in the bankruptcy court that there were 3 different tests, that was your own argument in the bankruptcy court.
What?
On appeal, you are saying there's only one permissible test. And I'm asking where you contended in the bankruptcy court that there was only one legally permissible test.
The pleadings and filings in the bankruptcy court did use the word insolvent in an errant way to characterize financial conditions that did not meet the statutory condition of insolvent. So I will concede that both sides' experts used accounting jargon.
I'm not asking about experts. I'm asking whether a lawyer representing your client ever told the bankruptcy judge that as a matter of law, there was only one legal standard. Was that ever argued to the bankruptcy judge?
The lawyer, I cannot say that that statement was made.
All right. I have to assume from the lack of any citations in your reply brief and what you're saying now is that the answer is no. This argument was never made to the bankruptcy judge. And now the follow-up question is, how can it be made today?
The argument to the bankruptcy court was that the debtor was solvent under any definition of insolvent. And
Look,
the difference...
I wish you would deal with my question. I said, we are now taking it as given that this argument that there's only one legal test was never made to the bankruptcy judge. How can it be made today in the Seventh Circuit?
It depends on what insolvent is meant to mean. The parties litigated sections 6 and 5 of the Uniform Fraudulent Transfer Act. And what the parties argued to the district court is they used insolvent as a shorthand for the financial conditions prescribed in sections 5A and 6 of the Uniform Fraudulent Transfer Act. The law is the law.
Counsel, I am asking a technical legal question about the nature of forfeiture in federal litigation, right? When you argue to the trial court that any of 3 tests should be used, when is it permissible to contend in the appellate court that only one of those tests is essential? You need to cite authority.
Well, we cite the Gerhardt's case where the trial court actually engages with the issue. In other words, this forfeiture argument was made to the district court, and the district court took up the merits of the argument.
The district court is not us.
So, the point I'm trying to make is that both parties were bound by the legal standards, and
Do you have some decision of this court saying that an argument forfeited in the district court can properly be raised on appeal?
Yes, Gerhardt's versus Rickard. I would say Gerhardt's versus Rickard is a case exactly like that. And Gerhardt's versus Rickard was a case in which a person had failed to raise the question whether or not a blood test had been taken without adequate exigency. The argument wasn't raised, and the district court had chosen to take up the merits of the argument anyway. And this court said that because the argument was...
I'm about to give up. The bankruptcy court never took up the argument that the balance sheet test was the sole permissible test. The usual way in which forfeiture arguments are phrased is that arguments never made or addressed in the trial court can't be resurrected. You're now citing a case dealing with an argument that was addressed in the trial court. Do you have a case dealing with arguments never made or addressed in the trial court?
Well, the issue of insolvency was addressed in the trial court.
I'm done. You're just not coping with my question.
I'm sorry, Your Honor. The other case we cite for the standard of review, which is In re Marcus Rettmeyer, states that we apply the same standard of review as the district court, and we review the legal conclusions of both lower courts for whether they're compliant with law. So between those, this is a case in which the merits were fully litigated. It wasn't until the bankruptcy court rejected Sefkew's evidence that showed that when you took account of all of the debtor's assets, There was nothing that could be characterized as insolvency, that it became important whether there was more than one definition of insolvency.
Mr. Dabney, can I ask you about another issue that
Yes.
the parties raised, which is the timeliness of the claims? So under your argument, I take it is that with regard to whether or not the trustees' claims were timely. Can you address for me your arguments with regard to that matter, please?
The argument is that the Illinois Uniform Fraudulent Transfer Act, Section 10, is a statute of repose, which requires that deems a right of action extinguished 4 years after the last event, and it's not subject to equitable tolling or anything else.
But hasn't the Illinois Supreme Court applied equitable doctrines in dealing with statutes of repose?
That argument, I have not seen that argument made. The trustee has made an argument in this case that Section 108 of the Bankruptcy Act renders the 4-year period extendable. We say in our reply brief we don't believe that is correct. This court's relevant precedent on that is Boyer against Crown Stock Distributors, and Boyer stated, an opinion by Judge Poser, that the filing of a bankruptcy
It does
petition,
not make any difference who writes the opinions of this court.
the filing of a bankruptcy petition was sufficient to invoke the 4-year bar, and we
So
believe.
I guess I'm looking at the Supreme Court cases I'm thinking about are Witherall versus Weimer, that's 515 Northeast 2nd 68, and that's the Supreme Court of the Illinois 1987 that applied the doctrine of equitable estoppel to a statute of repose, not this one, but to a different statute of repose, as well as DeLuna versus Burchiaga, which is 857 Northeast 2nd 229. That's a 2006 case, again, Illinois Supreme Court, that applied equitable tolling to a statute of repose. It seems to me that while generally speaking, I think you're right, as a general matter, that statutes of repose aren't subject to kind of equitable doctrine, because after all, that's the whole purpose of statute of repose, right? That the Illinois Supreme Court seems amenable, though, to apply equitable principles in addressing statutes of repose. And I was wondering whether you had a particular reaction to that proposition.
I confess I'm not familiar with the doctrines that hasn't been raised.
Let me, since your answer is you don't know, let me ask you a similar question to what Judge Easterbrook has asked about this timeliness thing. You note in your reply brief that you did contest it in bankruptcy court, but can you point us to where you did contest timeliness in your briefs or in the transcript in bankruptcy court?
The only place that was contested was in the answer. The trustee alleged that the complaint was filed within the 4-year look-back period, and trustee and SEPU denied that, and it was the trustee's burden to prove it. We are not relying on this as an independent ground for reversal in this case. We're saying that if the court reaches the merits, which we believe the court should do, that the bankruptcy court's own filings require that the judgment be reversed. There's never been a case in which less than all of a debtor's assets have been ignored, and the Poloyan versus LaSalle Bank rejected an analysis very similar to what was admittedly done here. That in this case, 85% of the debtor's actual assets were disregarded in the analysis that the trustee put forward. And it does not satisfy any of the statutes. That's the key point. That
I just want to make sure I'm understanding you. So you're no longer relying upon the timeliness argument.
no, we're arguing on the timeliness argument for the point that if the court reaches the merits of this appeal, which I believe are not forfeited, and this court should at all events exercise discretion to reach, that judgment should be entered for SEPU because there is no claim. The court could rely on timeliness as a basis for reversal, but in our brief we are relying on that because this was an issue that was not raised in the district court.
To engage on the merits then, under Section 5A2, capital B, it says, where the debtor intended to incur or believe or reasonably could have believed that it would incur debts beyond its ability to pay as they became due. Didn't some of the tests that the experts espouse address those issues? That is, wouldn't things like cash flow analysis and things like that be relevant to the issue of whether or not a debtor could have believed that the debtor would be able to pay the debts or not as they became due?
Absolutely right, but it's got to be all of the debtor's assets. The debtor's ability to pay, as on Boyer, in every case this court has ever considered, looks to all of the debtor's ability to pay. And in this case, the two charts on page 14 of the blue brief sum up the problem here. The so-called cash flow test applied by the trustee's expert looked at 1/7 of the debtor's cash assets rather than all of it, which is the same type of error that this court rejected in the Paloyan case. The analysis in this case, there was no dispute, no factual dispute as to what the value actually was or what discount rate should be applied. You either look to the entirety of the debtor's ability to pay or only just one small piece of the debtor's ability to pay.
Why then, since you want to talk about the merits, why then would the credit union's lawyer say, the cash flow test is important here then? I'm paraphrasing.
Because he was using that to refer to the absence of any proof of a default on any debt. The debtor actually did pay its debts. There was no proof. This is why the parties talked past one another, and accounting jargon ended up taking over the law in this case. So I realize I've come to the end of my time, so I appreciate the court's attention, but
Thank you, Mr.
the
Dabney.
merits should be reached in this case.
Mr. McClintock.
Good morning, Your Honors. May it please the court, Matthew McClintock, counsel for the trustee Sheldon Stone and the affilee in this matter. I wanted to start by quickly addressing the timeliness issue, because I think that one's fairly simple to address. And I know there was a lot of discussion about it. It's certainly our position that that argument was waived. Getting to Judge Lee's question, from our standpoint, we do think that this is probably a statute of repose, although, frankly, there's a lot of back and forth case law on whether it's a statute of limitations or repose. Is not very clear in the case law within the Seventh Circuit. We'd certainly take the position, however, that that statute of repose is not jurisdictional in nature. I think a statute...
I don't understand why there could be any jurisdictional question. The bankruptcy judge had jurisdiction. Statutes of limitations or repose have nothing to do with jurisdiction.
And I agree, Your Honor.
Now,
I think...
was there any dispute in the bankruptcy court, or for that matter the district court, about whether this request was timely under Section 546A?
There was not. That issue was not raised before the bankruptcy court or the district court. This is the first time.
That requires the fraudulent conveyance action to be brought within 2 years of the order for relief. In your view, what was the date of the order for relief? Maybe I should have asked Mr. Dabney that too.
Yeah, the order for relief is the date that a debtor files for bankruptcy protection. And here, the action was brought 2 days before 2 years, so 2 days prior to 2 years after the bankruptcy filing. And the one thing, beyond waiver on the substance of this timeliness issue, what I'd point the court to is that we discussed the 108 issue in our brief, that 108 provides 2 years. If a statute of limitations hasn't expired on the petition date, 108 provides an additional 2 years to bring that cause of action. But what I'd also point the court to is that the appellant said, well, 108 doesn't apply to an action brought under 544 of the Bankruptcy Code. And I'll first say there's a lot of case law that says 108 does apply to 544, and that's cases within the Seventh Circuit. But what the appellant doesn't note is that Section 546 of the Bankruptcy Code is critical because it provides the exact same 2-year period for bringing causes of action under Section 544 of the Bankruptcy Code. And there's myriad case law that both 108 and 546 toll the period for whether it's a statute of limitations or a statute of repose. So again, whether you're relying on 108 or you're relying on 546, there is a 2-year period from the bankruptcy petition, which is the order for relief, to bring this cause of action, and it's undisputed that the case was filed within that 2-year period and was thus timely. With respect to kind of the other big picture argument that the appellant makes, that is that the bankruptcy court applied the wrong legal standard for insolvency. And there, as we just heard, the appellant is arguing that there's only the balance sheet test under the Illinois Uniform Fraudulent Transfer Act, and points to Section 3, so 160/3 of the Illinois Uniform Fraudulent Transfer Act for that definition. I'll get to it in a minute. I disagree with that. I think there's several tests for insolvency within that definition. But I think that the key thing for this court to think about is that the bankruptcy court ultimately ruled for my client on 2 independent bases of the Uniform Fraudulent Transfer Act. That was, number 1, Section 5A2, and second, under Section 6 of the Uniform Fraudulent Transfer Act. And if you look at Section 5A2, that section requires 2 things. It requires first a finding of that the transfer was for less than reasonably equivalent value. Here, the bankruptcy court had detailed findings on that. That's not challenged. Then 5A2 requires one of either of 2 additional factors, and those factors are, number 1 is 5A2A, and I'll read what the provision says. It says basically that the transferor, quote, was engaged or was about to engage in a business or a transaction for which the remaining assets of the debtor were unreasonably small in relation to the business or transaction. That is what case law calls the adequate capital test. And the bankruptcy court made very detailed findings, that's at A47 to 48, that the adequate capital test wasn't met, that basically the bankruptcy.
Well, I take one of Mr. Dabney's points to be 5A2 doesn't discuss insolvency on its face. Is your response then, well, look at this part you just cited, it's obviously talking about the adequate capital test, if you're using it to apply it to the Illinois Act?
Correct. The court, it made very detailed findings on that specific issue. There's a whole section of the opinion devoted to the factual findings to determine whether the adequate capital test was met, and the court found that it wasn't, and so hence, it was appropriate to find for the trustee that under this particular section. I think where I understand the appellant takes issue is that the bankruptcy court reached the opinion also that the debtor was insolvent as a result of that finding. But again, the bankruptcy court made the independent finding that the adequate capital test, that the debtor at the time of the transfer failed the adequate capital test. So I think, again, you don't even have to get to insolvency to affirm that portion of the bankruptcy court's judgment. And I think the very similar thing applies to the other prong of 5A2, which is 5A2B, because again, the trustee really only needed to prove lack of reasonably equivalent value and then one or the other of the 2 subsections. So 5A2B, and again, I'll read what it says. It says, basically, did the transferor intended to incur or believed or reasonably should have believed that he would incur debts beyond his ability to pay as they come due? And that is what courts always refer to as the cash flow test. And again, the bankruptcy court had very detailed findings specifically on the cash flow test, and that's at A40 to 47. And again, largely based on the fact that.
Can we zoom out to where I think Mr. Dabney wants us to take us this morning on the waiver point? I heard him to be saying, we clearly didn't waive because we were discussing insolvency writ large. Insolvency is a large subject in bankruptcy court, and that's sufficient to avoid waiver here. Your response?
I mean, I was addressing the substance here of the bankruptcy court's ruling,
Right.
but
That's why I wanted to zoom out.
I agree, Your Honor. I mean, we certainly view this as waived. I mean, the bankruptcy court was very clearly addressing, it listed out these particular provisions of the Illinois Fraudulent Transfer Act that I'm addressing. it listed those provisions, and then it went through the elements of each thing, the cash flow test, the adequate capital test. The parties, everyone stipulated, or again, put aside expert reports, even in the briefing, none of the parties contested that there was not 3 different tests for insolvency. So the bankruptcy court did find that based on each test, the debtor was insolvent. But again, you could almost ignore that. It was almost a superfluous finding because it separately found that the cash flow test was failed, that the adequate capital test was failed. So it almost doesn't matter. So I certainly, I have no idea how this argument wasn't waived. It was not raised at all at the bankruptcy court level. And I'll note also that the bankruptcy court, beyond 5A2, the bankruptcy court also ruled for the trustee under Section 6, so 6A2 of the Illinois Uniform Fraudulent Transfer Act. And that section, again, it requires reasonably equivalent value or lack of reasonably equivalent value, which is undisputed. And then that requires either that the debtor was insolvent or became insolvent as a result of the transaction. And here's where I differ a little bit from the appellant, is that if you look at the definition of insolvency, which is at 160/3, the appellant argues that it's solely balance sheet insolvency, as you heard. But if you look at subsection B there's also a presumption of insolvency if a debtor is not paying its debts when due. And how do courts analyze that section B? If you look at the case law interpreting it, they look to the cash flow test. And we just talked about the bankruptcy court made very detailed findings that this entity failed the cash flow test for the relevant period, which, by the way, the court properly found the relevant period for the cash flow test to be 1 year. And it found that because almost all of the company's debts were coming due within that 1 year period. So that was the appropriate time to analyze the cash flow test. But again, because the court had found that this entity failed the cash flow test, it also found that, again, it fell within the definition of 160/3 as insolvent, and so thus it found for the trustee under section 160/6. So in sum, certainly from our position, again, this action was timely. The timeliness argument was in any event waived. And in addition, this entire, insolvency argument, number one, was waived and is directly contrary to what was argued at trial. But number two, even if it wasn't waived, again, most of the bankruptcy court's ruling really wasn't even dependent on a finding of insolvency. So happy to answer any other questions. Otherwise, I'll cede the podium.
Mm-hmm. Thank you very much, counsel. The case is taken under advisement.
Thank you.
We'll hear argument now in the case of McLean against Reynolds. Ms. Rowe.
Good morning. May it please the court. I apologize. Let me know if you can't hear me. I've got a cold this morning. My name is Crystal Rowe, and I represent the officers in this case. This appeal is very limited in scope. This court has appellate jurisdiction under the collateral order doctrine. That doctrine basically says that
we need to discuss that for a little while. Are you accepting the district court's summary of what the evidence would permit a jury to find?
I am, as facts, yes. We are arguing only on the legal analysis.
Your brief does not summarizes the evidence in a way very different from the way the district court did. Under Johnson against Jones, we're not allowed to look behind the district court's rulings about what evidence a jury could find.
Our brief was focused on the officer's knowledge. There's only 3 officers. The district court's factual findings dealt with everybody in this case. There are a lot of defendants. we believe that the qualified immunity doctrine, you have to know the knowledge of our officers.
I understand
and the
that, but
conduct.
the critical question is whether you unconditionally accept what the district court said a jury could find.
For purposes of today, yes, we do. Yes,
Okay.
we do, Your Honor.
Thank you.
But we still think the focus needs to be on the officers themselves in the qualified immunity doctrine. And to us, the legal question here has to do with what the district court found as what's clearly established law. And that would be the medical right of Ms. Chappelle to have someone other than an LPN look at this. Here, in this case, it's undisputed that the nurse was involved throughout this case. In fact, before the three officers at issue in this appeal, the nurse was involved before they ever got involved, and was, was ordering directions. The nurse ordered Officer Davison to take the temperature of Ms. Chappelle. He complied. The nurse, when something was happening, they would report to Ms. Chappelle. Now, there was an instance in the trial court's findings where the trial court believes that there was an issue of fact regarding whether the reports were enough. Especially she focuses specifically on the afternoon where Ms. Chappelle fell on the bunk, and it was unclear at first as to whether she had hit her head. And the court focused on that as being, that should have been reported to the nurse immediately. But the trial court's findings, the trial court's legal analysis is that, hey, a jury could determine that the officers are entitled to qualified immunity, but the jury could also determine that an LPN really isn't sufficiently credentialed to have diagnosed or treated. And to us, the established law that the court was relying upon comes from the Dobby or Dobie case. And in that case, and I'm sorry if I mispronounced it, but in that case, the court actually said that was the dental abscess tooth case. And in that case, the court says, these officers didn't report to anybody. They could have reported to even the pharmacist, the prison pharmacist. They could have reported to the medical technician. I mean, these people would not have the ability to diagnose and treat this dental abscess. But that was sufficient for the Dobie case. The problem in that case is the officers in that case didn't do that. Our officers did. They reported to Nurse Rutan. When they saw her stumbling and falling, they took it upon themselves to change her to a different holding cell.
Ms. Rowe, what about the district court's holding that the fact that, at least in the district court's mind, a jury could conclude, based on this evidence, that Officer Reynolds had reason to know that the nurse was failing to treat or adequately treat Ms. Chappelle, making his deference to Rutan unreasonable and indefensible, quoting Miranda. So basically, as I understand it, there's testimony about from Officer Reynolds and the other officers that, if in certain situations they had to alert or they had to get medical treatment for an inmate, and also some testimony that Nurse Rutan would sometimes perhaps not take complaints from inmates regarding their pain as seriously as and had a reputation for maybe discounting some of those statements. And it was based upon this, the district court said, well, yeah, but, a jury could find that Reynolds, based upon all this information, knew that whatever Nurse Rutan was doing was not enough. How is your characterization of the facts now not contrary to that district court holding?
The intent was not to be contrary. The intent was of the facts, and I apologize if it didn't come out that way, but the intent was to focus on what these officers knew and at the time, because to me, when I looked at the case, all the facts were in the aggregate of what all these different people knew. And in Miranda, they talk about how, these are departments and you divide up the labor, so to speak. And if you're looking, and the first thing I would say in response to that is with Officer Reynolds, that does not include Officer Davison's and Officer Stillwell. So that's one. And two, the impression I got from reading my take from reading the court's opinion, or the district court's opinion, was that it was when Officer Reynolds, the reason she focused on Officer Reynolds is because he had reported about the sickle cell disease. And then he said, well, it's not really sickle cell symptoms. And I think that almost puts a level on the officers who are not medically trained, to second guess the medical professional that they are reporting to. And that's the reason I think it's distinguishable in that respect. Another issue here is a legal issue of waiver. There were 3 briefs filed by the opposing side at the summary judgment stage. Not one dealt with qualified immunity. The district court acknowledges this, but says, well, they did cite case law predating 2021. But the case law, that is too general of a standard in our view, and I think our brief sets that out. I would like to reserve my time for rebuttal, if that's okay.
Certainly, Ms. Rowe.
Thank you.
Mr. Aguiar.
Good morning. May it please the court. Sam Aguiar here on behalf of Lavina McLean and the estate of Tanisha Chappelle. As was summarized, there's 2 main issues that appear to be addressed here. We've got the waiver issue. Certainly, as counsel, it's no fun to be standing up here and to have to basically defend my own pleadings and whether or not I adequately address qualified immunity. I do appreciate the district court's holding that this was complicated. We're dealing with 12 different officers. A lot of the arguments are intertwined. Certainly, we believe that we met our burden of citing a line of authority as it related to what was clearly established law that these officers knew on July 16, 2021.
What is the source of the clearly established law that you see?
Well, there's 2 different lines of clearly established law that are applicable to this case. One is that officers, plain and simple, have to provide access.
No. When I ask you for the source of clearly established law, I'm asking you for a citation, not for your description of what you think the law is.
Okay. Well, I'd have to refer to the footnotes in the brief, but there's certainly there's the Gayton case. There's Miranda. There's Petty's.
One reason I'm asking this is because it is an open question which the Supreme Court is inviting people to address, whether the law must be clearly established by decisions of the Supreme Court, whether law gets clearly established when an inferior court says something. Are you relying on any particular decisions of the Supreme Court?
Of the United States Supreme Court.
That's what we usually call the Supreme Court.
The question of medical care is addressed by the United States Supreme Court dating back to the 1980s.
In what?
And dating back to the 1980s.
I'm asking you for concrete citations, not decades.
As I sit here right now, I cannot recall the name of the case, Judge. Right. I apologize.
Well, this is not the case to broach that because it hasn't been raised by either party. But the Supreme Court of the United States obviously wants us to be thinking about it, and it's surprising to get a qualified immunity appeal in which no one pays any attention to this question. Anyway, please proceed.
We believe that clearly established law was raised adequately, not perfectly, and certainly it was relied upon by the district court properly, albeit with the judge acknowledging that we could have done a better job articulating it within a specific context. As it relates to the factual issues, even as I sit here today and hear what's being said, it conflicts and contrasts with the record evidence, the facts that we presented, and the facts that were accepted by the district court. 2 of these 3 officers in particular made no reference at all to going to the nurse to try to report any sort of problems. These 3 officers were literally tasked with observing Tanisha Chappelle on camera for hours, and the record evidence shows that they watched her deteriorate and ultimately she died. The nurse himself, when deposed, disagrees that Officer Reynolds came to him and expressed any sort of issues that needed to be addressed. So it's our position that for the court to accept jurisdiction of this case, it is going to inherently have to accept facts that are being presented now that differ greatly from what the record shows and what the underlying court found. I know that I have 10 minutes up here. I'm happy to answer any questions, but as it relates to the facts, all I can say is that they're different. And if the court wants to go to the merits, we can certainly do that. I'm happy to answer any questions from any of you.
So I take it so Ms. Rowe would like us to focus on what the officers knew and what the officers did from their point of view. I take it your argument is that given that Nurse Rutan seems to contradict some of their statements of what they reported, that a jury should be able to weigh both sides of that equation.
Yes, Judge, and I think that a jury could also look at the 3 to 4 hours of video footage where we see, thankfully, Officer Reynolds and Officer Davison together, as well as Officer Stillwell in a separate sector of the jail, side by side with what is going on with Tanisha Chappelle. They're observing the video. They're going to be able to conclude that she is getting worse rapidly and that there are no efforts being made.
I must say, counsel, if the problem in this case is that the three appellants were medically incompetent, what makes you think a jury is medically competent? Right? The question is not what lay people think by looking into the cell, but what we know from a medical professional.
The standard is objective reasonableness, and I think a jury is entitled to judge what is objectively reasonable.
I don't think we take that view in medical malpractice cases. Why would we take that view in constitutional tort litigation?
Because in a medical malpractice case, we're scrutinizing it from the perspective of a doctor. Here, we're scrutinizing it from the perspective of an objectively reasonable officer.
Do you have some law saying it's clearly established that you're supposed to apply a lay juror's perspective to the medical competence of prison guards? What clearly establishes that?
I'm sorry, that a jury is allowed to...
That we are supposed to apply a lay perspective to the medical assessments of prison guards.
I don't know if we have that.
No, I'm not acquainted with such a case. I
I'm not
didn't see
either.
it in the briefs.
We do have correctional experts that come in and discuss training, reasonable behavior, objectively reasonable behavior based upon training. The record in this case is going to show what these officers were trained. A jury is going to be able to analyze that.
And if I'm clear, for example, you pointed us to Miranda, our case, because you're talking about Seventh Circuit cases at this point. We do have law that a correctional officer can't defer to a medical professional if she knows or has reason to believe that the medical professional is not providing care for an inmate.
That's correct, Judge.
That's law you're referring to in that, if a guard is writhing in agony, a prisoner guard, if a prisoner is in agony, a guard can't ignore on the ground of not being a doctor or not making an effort to find a doctor, so forth, so on.
That's correct, Judge. We've also cited to the deposition testimony of the officers themselves that acknowledged that it was obvious that she needed to go to a hospital, that she was obviously suffering, and that, and certainly we believe that a jury can take that into account as well.
Well, thank you, Mr. Aguiar.
Okay. Thank you, Judge.
Anything further, Ms. Rowe?
Real quickly. First thing I would say with respect to the facts in this case is that the doctrine of qualified immunity shields government officials from civil liability unless the official violated a statutory or constitutional right that was clearly established. That is why I believe the focus is on what the officers knew and what their conduct was. Because that's what we're talking about, is the qualified immunity doctrine as to each of these officers individually. With respect to the two officers, we heard that two officers made no reference in the facts to going to the nurse. That would be Officers Davison and Officer Stillwell. But both of those came into the picture with the nurse. Officer Stillwell was directed by the nurse to take the temperature, so he knew the nurse was involved the entire time. Officer Stillwell, that was Officer Davison, sorry. Officer Stillwell went with the nurse the first time he saw her and saw the nurse interact. He saw her take Ms. Chappelle's blood pressure, etc. So they knew the officer. They were also hearing, again, it's just the division of labor in this thing. With respect to the clearly established law, the cases that talk about that Your Honor was talking about, with respect to, they're all talking about when the officers or when the nurse is providing no care. There's no cases that talk, that at least in the application, Miranda is the same, that talk about how the officer is supposed to somehow have better knowledge than the nurse, who is the medical professional under Dobby. That would qualify as a medical professional. And that, I believe, is what the standard is being used here by the district court, is that they should have known better than this nurse. And with no other questions, Your Honor, I thank you for your time.
Thank you very much, counsel. The court will take a brief recess before calling the next case for argument. We're ready to hear argument now in the case of Moore against the Commissioner of Internal Revenue. Mr. Addis.
Good morning. May it please the court. At the outset, Your Honor, may I refer to the Internal Revenue Service as the IRS?
Sure, that's a common enough acronym.
Thank you very much. The question before this court is what type of written records, if any, must a taxpayer maintain in order to take a research tax credit? That is the only question before this court. The tax court held that despite...
Why? The
Pardon?
tax court made some findings of fact, and it does seem to me that they are adverse to your client. And unless you can show that the findings are clearly erroneous, you have trouble.
Well, Your Honor, the findings I don't think are clearly erroneous. The tax court kind of left our client hanging, so to speak, in that it held that but for some written record of the time spent by a particular employee, that employee's actions did not qualify as qualified research or the direct support or direct supervision of that qualified research. And because of the lack of those written records, the tax court said we cannot allow his compensation to be used in the calculation of the research tax credit. In addition,
Let's broaden this out. What kind of world would you prefer? The tax court to listen to Mr. Roberts' testimony and say, okay, accepted?
or the alternative?
What is the alternative to some sort of substantiation by Mr. Robert that you are arguing for?
Well, Mr. Robert, in preparing NEVCO's preparation of the tax returns, which included this claim of the tax research credit, Mr. Robert worked with NEVCO's tax accountants and tax return preparers in determining what percentage of his time was actually spent on research, which would qualify for the tax credit. And so that evidence right there should be sufficient to support the research credit.
But counsel, wasn't your client on notice based upon the regulations, namely 26 CFR section 1.41-4D, that a taxpayer claiming the credit must retain records in sufficiently usable form and detail to substantiate the expenditures? And so shouldn't your client have known that they needed to provide some documentation along the way that could substantiate the expenditures that Mr. Roberts, whether all or portion of his salary was categorized under this particular statute?
Yes, they should have been put on notice. I agree with that.
And the reason I bring that up is because I think in your briefs you rely on Coyle, right? The 1926 whatever case, where if a court finds that some of the acts are deductible, then the court should engage in some sort of reasonable calculation of what that is. But here, given this particular regulation, I guess I'm surprised that your client didn't have any documents to satisfy this regulation. And given that the client didn't, I'm surprised that your client is pressing the appeal before us in the face of that regulation. I'm wondering why you think, what your best argument is that that regulation doesn't apply to your client.
Well, first of all, to the extent there are written records, and I emphasize the word written, because that's what the tax court emphasized, written records. Because there are records that are not written. And so to the extent written records are required, the payroll of Mr. Robert is certainly a written record to support the expense of his compensation.
And is your position that
it doesn't remotely deal with the question what percentage of the research he supervised was qualified? The critical question on which you lost in the tax court.
I agree with your assessment there, Your Honor, but I would also say that for NEBCO's many other employees, specifically engineers, they didn't require written records to support the use of their salaries for the tax research.
You shouldn't go too far with an argument that things could have gone even worse for you, right? The commissioner, in a sense, cut your client a break by conceding that Roberts' subordinate was engaged in qualified research. But all we have to do now is deal with the deductions for Roberts. And there, the question is, what part of the research was qualified? And on that, as far as I can see your argument, you don't even contend that there are any written records of any kind.
You are correct.
Do you argue that the regulation is invalid?
No, we do not. We
Okay.
argue that
Well,
his testimony in
testimony is not a written record.
Well, again, Your Honor, there's no requirement of a written record.
Well, you just told us that they had payroll, and payroll was a written record. Did I hear you say that
I
correctly?
did say that.
But what does the payroll establish about the percentage of his time spent on qualifying research?
It does not. I reserve the balance of my time if I could.
Certainly, counsel. Mr. Jones.
Good morning, Your Honors, and may it please the Court. Sam Jones here on behalf of the Appellee Commissioner of Internal Revenue. Taxpayer Scott and Gayla Moore's claim for a tax credit under Section 41 of the Internal Revenue Code rests primarily on their contention that Gary Robert, the former president and COO of the taxpayer's wholly owned corporation, performed qualified research. But as the tax court correctly found, there's no testimony or documents in the record showing what amount of time, if any, that Robert spent actually performing qualified research, a precisely defined term under Section 41. The taxpayers instead rely on Robert's estimate that 65% of his activities involved new product development. But as the taxpayers have already conceded below, new product development as they have defined it is not the same as qualified research under Section 41. This is fatal to their claim. And with that, if the court has any questions, I'm happy to answer them.
Thank you very much,
If
Mr.
not,
Jones.
yes, sir. Thank you.
Anything further, Mr. Addis?
No, Your Honor.
Well, thank you very much. The case is taken under advisement. Our fifth case for argument is Reynoso Salgado against Garland. Mr. Cabranes.
Good morning, Your Honor.
Before we begin, Mr. Cabranes, I am worried about your compliance with Circuit Rule 30, which requires the appendix to contain a copy of the decision being appealed. And as far as I can figure out, the thing in your appendix purporting to be the decision of the Board of Immigration Appeals is not.
I don't understand.
Where did it come from? It is not the document in the administrative record. It appears to be something that's been typed from scratch and poorly, with full of errors and omissions. It is not the genuine decision of the Board of Immigration Appeals.
Judge, I'll begin by saying that the filing of the brief was not the finest moment of our law firm. I have, and I'm getting to answer your question. I'm going to answer your question directly. I have been sick essentially since June of last year. I have had 100% turnover in my staff. So I have,
But it's a lot easier to file the real decision rather than a fake one.
well, I don't think it was a fake one, Judge. I think what happened was there was a problem with the scanning of the original decision. It formatted it in such a way that it essentially, it mixed and matched, and everything was a chaotic mess in that. And I think that one of my staff, and first of all, I take full responsibility. It's my signature on the document. I take full responsibility for it. But I suspect that what happened was that because the original was so messed up that we had, that somebody took it upon themselves and copied it and formatted it properly with, I don't know what happened, Judge. All I can tell you is this is what I think happened, and whatever sanctions the court feels the need to impose, I recognize that this was again, not the finest hour, not my finest hour.
Now, let's proceed with the merits.
Thank you. Judge, on the issue of the standard of review, I think is kind of the central issue to this case. We take the position that this is not a Chevron case, that the intent of Congress can be, in fact, determined based on the common meaning and usage of the words in the statute. There's a case. You'll have to excuse me, Judge. I'm a little flustered right now. And there's a case, Rodriguez versus Rodriguez, which was I'm sorry, In re Rodriguez, 22 IN, December 1991, which was one of the first cases from the Board of Immigration Appeals that dealt with this issue. And they indicated that the issue in terms of child abuse, in terms of child neglect, really required a harm. The subsequent decisions also required a harm. And I think that reading makes sense when you look at what the common usage of the term child abuse, child neglect, back in the mid-90s was. Because the majority of the states in this case had a scheme, so to speak, of just one second, Judge. This is part of my issue that I've had for the last year. It's part of a scheme that the states had, that the states had, that I believe it was 35 out of the 50 states required some level of harm to the child in order for it to be considered child abuse. So that's the context under which the Immigration and Naturalization Act, these particular amendments, or this particular section, I should say, was called into creation. There is a case, and it's a 10th Circuit case, and I know that it's not binding on this circuit, but it is I think, instructive.
It is uncertain whether you would prevail under the 10th Circuit case, but the Attorney General's brief says that a whole bunch of other circuits have disagreed. Do you disagree with that proposition?
No, Ibarra stands out like a sore thumb in terms of dealing with the current law. There is no other circuit that I am aware of that has looked at Ibarra and said, and followed Ibarra. And honestly, I think that is a certain amount of inertia on behalf of the other circuits.
It's not inertia when a court of appeals says, we disagree with decision X. You might say inertia would be just falling along in line. But when you have a circuit that says something and 5 other circuits say baloney, that's very hard to describe as inertia.
Well, I think that Ibarra is well thought out.
Are you referring to Ibarra?
Ibarra, yes. That's the 10th Circuit case that I'm talking about.
Yes, I-B-A-R-R, not I-V.
I said Ibarra. I'm sorry. I'm pronouncing it differently, but it is Ibarra is the case.
I-B-A-R-R-A.
I don't think you need to apologize, Mr. Cabranes. I think you can proceed with the case. We know which case you're talking about.
Thank you. I think that the 10th Circuit case is well thought out. It was well laid out, and it makes sense. And when you look at it, even the present case that the Board of Immigration Appeals has now and uses as its standard, the Sorum case. The Sorum case, in its concurring opinion, follows along, and this was before the 10th Circuit case came along. The 10th Circuit, the In Re Sorum, they use the same essentially approach, but come up with a different conclusion. So the approach used by the 10th Circuit is not way out in left field. It's just that other circuits have disagreed with that approach. And I'm asking this circuit to consider what the 10th Circuit has looked at and made a determination that the intent of Congress was not to have these child abuse cases where there's no actual harm to the child. I see that I have 2 minutes left, and I'd like to reserve that for rebuttal.
Certainly, counsel. Ms. Snyder.
Good morning, Your Honors, and may it please the Court. My name is Alana Snyder, and I'm appearing today on behalf of the United States Attorney General. Respectfully, we're asking Your Honors to deny this petition for review for 2 reasons. First, the Board's definition of crime of child abuse, child neglect, or child abandonment pursuant to 8 U.S. Code Section 1227A2EI is reasonable and therefore entitled to deference.
Ms. Snyder, Chevron
Yes.
is being considered by the Supreme Court,
Yes.
right, as we speak. Maybe even right now, who knows? Although I think they're in an argument right now.
We know it didn't come out today, though.
Yes.
Right. And likely, most likely, it's probably not going to come out till, I don't know, if I were to prognosticate, probably till June, right? So what do we do with this case, right? I mean, there are various ways of looking at it, and certain circuits have looked at it differently, right? So there's, even under Chevron, there's step 1. And then the question becomes, under current Supreme Court doctrine, like, we are supposed to use all normal tools of statutory construction. And as far as I can tell, under that formulation, very few courts have found this to be ambiguous, right?
In fact, none.
And so, that seems to be the logical conclusion of that test, because that's what we do, right? We use normal canons of statutory interpretation to resolve all of our cases or that deal with statutory language. And so, what do you suggest that we do in this case?
Sure. The government's answer to that is Chevron remains the law of the circuit, and there are circuit courts who have been faced with this issue, particularly the 3rd, the 11th, and actually very recently, just as recent as last week, the 2nd Circuit in an immigration case, Wong versus Garland, actually had a similar issue and sort of noted in a footnote, we recognize that Loper, Bright, and Relentless are pending, but Chevron remains the law of the circuit. I think as an alternative sort of argument that we'd posit before Your Honors, that no party in Loper, Bright, and Relentless really disputed the fact that Skidmore deference, or that Skidmore would still remain good law. So if Your Honors find that Velazquez, Herrera, and Sorem are thorough in their reasoning and are of sound reasoning, and that later pronouncements of the board, for example, matter of Mendoza-Osario and matter of Rivera-Mendoza, are consistent, and the Board of Immigration Appeals remained consistent, that Your Honors could sort of, I hesitate when saying this, preserve the court's sort of this decision by citing to Skidmore and saying, you know, we look at this also with the Skidmore eye, if you will. And as Judge Easterbrook sort of noted, that there are 6 sister circuits or 6 of your sister circuits who have already deferred to the board's definition of crime of child abuse, child neglect, or child abandonment. And I'd note that these 6 circuits all share 2 commonalities. The first, as Your Honor just pointed out, is all of them have determined that that phrase is ambiguous. The second is that all of them have deferred to the board's definition of crime of child abuse, child neglect, where the minimum mens rea is criminal recklessness, even where there is no resultant injury to the child. And we're asking Your Honors to join those circuits today. And I'd like to sort of highlight some differences from my friend's position today. So one of the points of contention, I think, between my friend and I is the criminal negligence issue. And I think that was the main issue in Ibarra, that the minimum mens rea in Ibarra was a criminal negligence. Here, the statute at issue, the Wisconsin statute at issue, the minimum mens rea is intentionality. There's no question of criminal negligence that's before the court. There are 2 circuits, the 3rd and the 5th Circuit, who faced the same issue and reserved decision on the question of criminal negligence. So the court doesn't even need to touch the Ibarra issue, if you will. So unlike my friend who's suggesting, you know, the court needs to grapple with this issue, that issue is not even really before the court. And I'd also note that the 10th Circuit, in a later decision, a 2021 decision named Zarate-Alvarez, actually did come out and say that was what we were dealing with in Ibarra. That was sort of where the rubber met the road, the criminal negligence versus recklessness issue. And where it came to a statute, it was actually the very same Colorado statute that instead didn't deal with negligence but dealt with recklessness. They actually did defer to the board's definition where that mens rea was recklessness. I'd also like to address my friend's point about the majority of states having a statutory scheme that required harm to the child. I know this is also a point of contention between my friend and I. I'd like to note that the board doesn't need to take any sort of statutory interpretation or state-by-state interpretation. It's not required to use any statutory method of interpretation. The idea is that the Board of Immigration Appeals takes a sort of creates a uniform approach for a definition of crime of child abuse, child neglect, or child abandonment as the agency that creates a federal policy for immigration. I'd also like to note that petitioner stated relies on In re Rodriguez.
Can we talk about that a little
Yes,
bit? So the
please.
statute has 3 elements, right?
Yes.
Crime of child abuse, child neglect, or child abandonment.
Yes,
And yet the agency applies this kind of unitary approach.
yes.
And can you explain to me why that unitary approach would be permissible or reasonable, given the fact that the statute itself specifically delineates each separate one?
Yeah, I think the best explanation for that is the fact that each one of those individual pieces does not say the word crime of before it. So it's crime of child abuse, child neglect, or child abandonment. And permit me to just open to the statute why I have this big binder here. Just give me a moment. And it's sort of contra to the other provision of the statute. This is 1237. So as you can see in 8 U.S. Code Section 1227 A2EI, you can see any alien who after the time of admission is convicted of a crime of domestic violence and then a crime of stalking, right? So you have 2 separate a crime of, and then it says, or a crime of child abuse, child neglect, or child abandonment. And so the logic there is the best statutory interpretation is that is one specific crime. That does not refer to individual crimes. Otherwise, the statute would have said a crime of child abuse, a crime of child neglect, or a crime of child abandonment. That was the logic of the board.
I'm now thoroughly lost, because on that view, it sounds like one state law must cover all three things: abuse, neglect, and abandonment.
I think,
And if the state law doesn't cover all three, if it covers, for example, only child abuse, it wouldn't qualify.
I think the logic there is maybe perhaps the opposite, that if the state statute covers any of those things, if it falls under, and I think, let me back up and say that part of the difficulty is that some states cover, say, behavior like we have here, endangerment. They cover that behavior as child abuse. They cover that behavior as child neglect. So the board was looking at, well, how do we determine whether or not endangerment is covered as neglect, it's covered as abuse? So it looked at that definition and said, it's one definition, whether the state defines it as abuse or neglect. I know it's confusing.
It seems very convenient for the agency, is what it seems like.
Because it's a unitary definition. I think the board sitting down did what it is supposed to do, which is to look at, as Your Honor sort of pointed out, to look at those canons, to look at, what was at the time the federal definitions of, child abuse, look at different state definitions of child abuse, to look at, Black's Law Dictionary in 1990.
Where did they refer to a federal definition of child?
So in a number of...
There are federal statutes.
Yes.
And some of the provisions in the Immigration Code expressly pick up federal statutes.
Yes.
But this one is not among them, so why would we be looking at a federal definition?
The board did, in a number of footnotes in Velazquez-Herrera, note to its consideration of...
But is that supported by language in the statute? Or are you playing the game of Taylor, that when there is no express federal definition, you have to make up a federal common law definition? That's what Taylor says about 18 U.S.C. Section 16.
Yes. I think that is part of this, that you have to employ the statutory and tools of interpretation in order to come up with the generic definition. As Your Honor pointed out, there is no... May I continue? I'm sorry, I see that there is no generic or common law definition.
That's why I didn't understand your answer to Judge Lee, that we have two options, Chevron or Skidmore. Don't we really have a third option that doesn't involve the board's interpretation at all, and we just dive in?
De novo review.
Yes.
Sure. If Your Honors wanted to de novo review, yes. Thank you, Your Honor.
All right, thank you, counsel. Anything further, Mr. Cabranes?
Judge, I think I've covered what I need to cover. Thank you.
All right, thank you very much. The case is taken under advisement. And our final case of the day is United States against Ponley.
Morning, judges.
Mr. Nash.
I please the court. I'm Michael Nash. I'm appearing for Jacob Ponley. The sole issue here today is whether in the context of the sentencing guidelines 2B1.1, whether the word loss is ambiguous. I think that in retrospect, the government is correct as to the number of victims, so we would abandon that argument. I think from my point of view, or from Mr. Ponley's point of view, we would point out that 2B1.1 talks about loss in terms of dollars, not something else, not loss of a loved one, not being lost, but loss in terms of dollars. And there's no ambiguity there. I think that the opinions expressed by the court in Alford and in Banks, the Third Circuit case, are persuasive and much more persuasive than the Sixth Circuit's decision in you, which we cite in our reply brief.
Mr. Nash, so the way I kind of conceptualize the main issue here is whether or not Kaiser overrules Stinson, right? And I know that there's lots written about this, but one of the things that to me differentiates, particularly here, the Sentencing Commission's commentary with regard to loss to the agency's interpretation of its own regulations under Kaiser is that in 2001, it appears that the Sentencing Commission actually published its commentary that it thought loss would be actual as well as intended loss for notice and comment in the Federal Register.
They did, and then they abandoned it the next year, and it doesn't appear again, as I researched.
Well, they received in 2001, they received comments, they published their response, and that's kind of what led to the commentary that's currently in the Sentencing Guidelines Manual. So basically, isn't the fact that this particular issue was published and sent out for notice and comment and went through that process, right? Whereas the agency interpretation, Kaiser, didn't. Doesn't that distinguish what we do or what the Sentencing Commission does with the sentencing guidelines from what the agency did with its regulations in Kaiser?
Well, they changed it from intended loss to loss, and it's been a loss for all these years. Actually, funny that I use that word. If in Word you were to type the actually what occurred, Word would correct you and say, forget about the word actual. If you type the word loss in and set actual loss, it would correct you and say, don't put it in. Not that that's a legal argument, but grammatically, I think I almost want to say common sense, but obviously others disagree with that.
You are correct that the Sentencing Commission, walked it back, and all these years we have the word loss. But if we take that history, what are we to make of the fact that now the Sentencing Commission is considering putting intended loss in the text of the guidelines? Where does that put us?
Puts it that they didn't like banks and they didn't like the decision and they want to stay with intended loss. But at the time this defendant was sentenced, the word was loss. And it wasn't loss of anything but in terms of dollars. And the government and the defendant agree that the loss amount was $8 million something, not 52.
But that's if you ignore the commentary, right? If you ignore the commentary.
Correct.
And I guess my question is, why do we need to ignore it since it's there and it was put through notice and comment?
Because loss is not ambiguous. Loss is very clear. Nobody could, again, I know people disagree with this.
But we don't have to refer, we're not limited to referring to the commentary only when the term is ambiguous.
I believe it's got to be genuinely ambiguous. I believe that's the holding of Kaiser.
It certainly isn't the holding of Kaiser.
I would agree.
Kaiser does not overrule Stinson.
It does not.
And the Supreme Court has said more often than it should need to, that we are supposed to follow their decisions until they overrule them.
Correct.
How is that consistent with your position that we should just ignore Stinson?
It makes it more difficult, but I think the term loss is not, in what the Kaiser court said, genuinely ambiguous. If we're talking about dollars and there's a settlement conference and the judge asks for what's your offer and the fellow says $340,000, he means dollars, and that's what they're talking about here. If I may, I'd save a little time for rebuttal unless there are more
Certainly,
questions.
Mr. Nash.
Thank you, Judge.
Ms. Alexakis.
May it please the court, Georgia Alexakis representing the United States. The district court here did not err in calculating the defendant's guidelines when using intended loss to determine his offense level. And this is true whether this court analyzes the meaning of loss purely under Stinson and this circuit's precedent, or after it accounts for Kaiser. I would agree with Judge Easterbrook that Kaiser did not overrule Stinson. It explicitly stated that it was not overruling Seminole Rock, Auer, and then in a footnote goes on to cite a whole series of cases, including Stinson, that fall into that camp. I would say, and I think the government has set this out in its brief, that this distinction between...
You know, of course, that the Solicitor General has told the Supreme Court that Kaiser did supersede Stinson. Now, why in the world? I've been having trouble. You may know that there are multiple cases just like this pending before multiple panels of the circuit. And one of the problems has been, I think, that the government is trying to talk out of both sides of its collective mouth. So in your view, representing the United States as an institution, is Stinson alive or dead?
Judge, and I should be clear, this is not my personal view, this is the government's view.
Yes, I'm asking for the view of the United States.
Sure, and I think our brief sets it out and cites to the Solicitor General's filings in front of the Supreme Court, where I would disagree respectfully that the Solicitor General has said that Kaiser displaces Stinson. I think what the Solicitor General has said is that Kaiser and Stinson work in tandem together. That Kaiser informs the analysis under Stinson. Stinson tells us that the commentary is authoritative unless there is an inconsistency between the guideline and the commentary. Kaiser takes us back a step and helps the parties and the courts determine whether that inconsistency exists by directing courts to first consider whether the regulation, or in this case, the text of the guideline itself, is genuinely ambiguous. Where there is ambiguity, there cannot then be inconsistency between the guideline and the commentary. And so here, where loss is genuinely ambiguous for the reasons set out in the government's brief, where there is more than one reasonable construction of the word loss, there cannot be an inconsistency between loss in the guideline and intended loss in the commentary, and therefore the district court did not err in relying on intended loss when calculating the defendant's guideline.
Is that a very long way of saying the government wins under Kaiser or Stinson?
I think it is. I think it is, Judge Jackson-Akwumi. Although, again, respectfully, I would disagree with this notion that the government is, trying to have it both ways. I think the government is trying to reconcile the court's analysis in Kaiser in a world in which the Supreme Court was quite clear that it was not overruling Seminole Rock or Auer or, relatedly, Stinson, and that instead Kaiser was simply clarifying those instances in which courts should rely on an agency's interpretation of a regulation, or in this case, the commission's commentary itself. And so here, having looked at the text, the structure, the purpose...
I appreciate the difficult position you're in. The Solicitor General's position is not pellucid. And of course, the Solicitor General has not sought certiorari in the cases from the Third and Fourth Circuits that the government has lost outright on this question.
I
know
sure
it's not
you're
the
right,
right
Judge.
question to ask you, but are they waiting for Loper-Bright? We discussed that in the last case.
These are discussions that I am not privy to. I'm not privy to, Judge. But I do
And
think
if you were, you couldn't tell us because it would be covered by the attorney-client privilege.
I think that would also be true, Judge. Yes. I think ultimately I would rest on the government's briefs and the arguments set forth there as to why loss is genuinely ambiguous under the Kaiser analysis, and therefore why the district court did not err and then importing a meaning of intended loss when calculating the guidelines. Are there any questions? Thank you.
Thank you, counsel. Anything further, Mr. Nash?
Very briefly, Judge. Listening to the court's questions and the prosecutor's answers, I'm reminded of what Kaiser said in one portion of its decision. I don't remember whose opinion it was, though, in that case. Not to defer to convenient litigating position to defend agency action. And I must say, when I read the government's brief,
That loses me. The Supreme Court has never deferred to litigating positions.
no, what they're
But
talking
the
about.
note in the guidelines is not a litigating position.
When I'm talking about their position in this case, and I think they're defaulting to a litigating position to defend what happened in this case.
No, the note in the guidelines is not a litigating position. When that issue arises in Chevron terms, they're referring to what's in briefs rather than what's in legal documents like regulations.
And what I'm referring to is what's in their brief in this case. And that's all I have to say, Judge.
Okay, well, Mr. Nash, we appreciate your willingness to accept the appointment in this case and your assistance to court and client. The case is taken under advisement and the court will be in recess.